This is Justice, History, and the Law. Lectures, discussions, and interviews from the Robert H. Jackson Center in Jamestown, New York.
In part one of today's show, we have a speech from the Chief Justice of the United States, William Rehnquist, from 2003. And in part two, Eli Rosenbaum speaks about his office, the Office of Special Investigation, from August of 2009. Now for part one.
Now to introduce the Chief Justice of the United States, I am honored to introduce Professor John Q. Barrett, the first Elizabeth S. Lennay Fellow of the Robert Jackson Center. Professor Barrett is a professor of law at St. John's University in New York City and has a long and distinguished resume, including being a graduate of Georgetown University and Harvard Law. From 1986 to 1988, he was a law clerk to Judge A. Leon Higginbottom of the United States Court of Appeals for the Third Circuit in Philadelphia. Professor Barrett's edited version of That Man, an insider's portrait of Franklin D. Roosevelt, Justice Jackson's previously unknown, never before published New Deal memoir, will be published this summer by Oxford University Press. Professor Barrett also is writing a biography of Justice Jackson that will include the first inside account of his year away from the Supreme Court as the chief American prosecutor of the principal surviving Nazi leaders at the International Military Tribunal at Nuremberg, Germany. Ladies and gentlemen, I'm thrilled to introduce Professor John Barrett.
Thank you very much. It is an honor for me this morning to have this privilege of introducing William H. Rehnquist, the Chief Justice of the United States. Chief Justice Rehnquist was appointed to his present office by President Reagan in 1986. He previously had served from 1971 until 1986 as an Associate Justice of the Supreme Court. He was appointed to that position by President Nixon. His total service on the Supreme Court thus now totals over 30 years, which makes him one of the longest-serving Supreme Court justices in our nation's history. An interesting path brought Chief Justice Rehnquist to this distinguished destination in public service. He is a native of Shorewood, Wisconsin, which is an early and lakeside suburb of the city of Milwaukee. After his high school graduation and a year of college, he served our nation in World War II in the Army Air Corps. He was stationed in North Africa and spent years there in weather observation and other service. After the war, and having experienced a more salubrious climate perhaps than his native Shorewood, Wisconsin, he hitchhiked with a friend across the American West, looking, among other things, for someplace more like North Africa than Milwaukee. And he found Northern California, and he used his GI Bill benefits to complete his college education and to earn a master's degree at Stanford University. At that point in his life, he was inclined to pursue a career in academia as a political scientist, and so he earned a second master's degree at Harvard University. He then, however, reconsidered that early career choice and perhaps that geographic slip and returned to Stanford, where he earned his law degree in December of 1951. He went through law school in a somewhat Jackson-like fashion on an accelerated pace, feeling that his military service had put him behind some of his contemporaries. And so he graduated in 2.5 years by going to summer sessions, which is not an insignificant fact. He graduated first in his class from Stanford and became a member of the bar shortly thereafter. He settled in Phoenix, Arizona, and was a successful trial lawyer there during the 1950s and 1960s, and was active in Republican Party politics. In 1969, following the election of President Nixon and the appointment of Arizona lawyer Richard Kleindienst as the Deputy Attorney General of the United States, he was invited to and nominated to and confirmed to serve in the Nixon administration as the Assistant Attorney General heading the Office of Legal Counsel. The Office of Legal Counsel is known and highly regarded throughout the legal profession as the constitutional thinker of the executive branch of the government. And he served in that position for more than 2 years. Among many tasks in that public service legal capacity, he worked on the first 2 Supreme Court appointments by President Nixon, the appointment of Chief Justice Warren Burger and Associate Justice Harry Blackmun. 1971 brought change to the Supreme Court with the retirements of Justice Hugo Black and John M. Harlan. President Nixon appointed a distinguished Richmond, Virginia lawyer, Lewis F. Powell, former president of the American Bar Association, to succeed Justice Black. And he appointed Assistant Attorney General William Rehnquist to succeed Justice Harlan. Now, in this biography, you will have noticed that I've skipped an obvious and important step. From February 1952 until June 1953, as his first job following law school, William Rehnquist served as a law clerk to Robert H. Jackson. A law clerk is an in-chambers direct employee and assistant of a judge, in this case a Supreme Court justice, to be used on the inside in a highly responsible, highly confidential position as the justice sees fit. Justice Jackson had William Rehnquist and a co-clerk with him for the 18 months that Mr. Rehnquist was a law clerk. And that working relationship, obviously, was his first opportunity at the Supreme Court, a very special direct exposure to the work of the court, and obviously a direct and intimate working relationship with the man who we honor and who this center honors today. There are, of course, many reasons why William Rehnquist got to be a law clerk to Robert H. Jackson. His own ability and accomplishments obviously top that list of reasons. But there is, and I note on this rainy day, ironically, a serendipity directly connected to Jackson's love of the outdoors and the beauty of nature that played a role in Mr. Rehnquist becoming law clerk Rehnquist, and of course everything that thereafter followed. As you know, Jackson was born in Spring Creek and grew up in Frewsburg, and as an adult lived here in Jamestown, and loved this land, and walked these hills, and swam in that lake, and rode his horse in these valleys, and was a man of the land. From 1934 until the end of his life, his home was in Washington, D.C., but he always returned to this area and loved it, and also loved the land of Virginia, as Melissa described Nancy's vision, the man on the horseback riding out of the woods. In addition to returning to Jamestown and loving Virginia, however, he also, beginning in the summers following his Nuremberg service, spent 2 weeks each year in the woods of Northern California, a place that he found captivating. And I think, having now seen both, in some ways there's a surprisingly direct comparison between those groves north of San Francisco and the groves here in southwestern New York State. As luck would have it, his second law clerk, a gentleman named Phil Neal, who was here with us last October, had become a law professor at Stanford University. And so the serendipity of nature and Northern California and Phil Neal and Stanford becomes the connection to William Rehnquist. In 1950, Professor Neal invited his former boss, Justice Jackson, to dedicate a new law school building at Stanford. That was a year in which Phil Neal was teaching a student named William Rehnquist. During the next summer, on an impromptu basis, Justice Jackson and Mrs. Jackson returned to Palo Alto, and while visiting the Neals, took a bit of a side trip to the campus, where Justice Jackson was introduced by Professor Neal to his star student, William H. Rehnquist, which became an interview, which became a connection, which became a job offer, which became a clerkship. In December 1951, Justice Jackson wrote to almost graduating Stanford Law School student William Rehnquist, "I felt that at our talk at Stanford that you and I would get along pretty well together. And if we can make proper arrangements, I will be glad to take you on." I know all of Jamestown and this region joins with me in echoing that Jackson sentiment. We will and we are here today getting along pretty well together with Chief Justice Rehnquist. And in Jackson's phrase, it is a high honor that he is taking us on and dedicating the Robert H. Jackson Center. The Chief Justice of the United States, William H. Rehnquist.
Thank you. Thank you. Great honor to be here. Thank you, Professor Barrett, for the kind introduction. I'm delighted to be here for the dedication of the Jackson Center. I served as one of his law clerks for a year and a half, and it was one of the most rewarding experiences of my life. Justice Jackson served as an Associate Justice of the Supreme Court from 1941 until his death in 1954. And during these 13 years, he made significant contributions to the court's jurisprudence. But unlike any of his colleagues, before or since, he was a principal architect of the Nuremberg war crimes trials held immediately after World War II. He described this effort as the supremely interesting and important work of his life. So a good portion of my remarks will be devoted to that aspect of his career. He was born, of course, in 1892, grew up here in the Jamestown area. He was admitted to the New York bar without having a law degree and developed a very successful law practice here. He was also active in the state Democratic Party and as a result became a friend of Franklin D. Roosevelt. After Roosevelt became president in 1933, he brought Jackson to Washington as general counsel to what was then the Bureau of Internal Revenue. Jackson rose rapidly in the executive hierarchy, serving as Assistant Attorney General in the Antitrust Division, Solicitor General, finally Attorney General. Justice Louis D. Brandeis expressed the view that Jackson should be Solicitor General for life, a high compliment from one who did not bestow compliments casually. When Roosevelt elevated Harlan Stone to the Chief Justice in 1941, he appointed Jackson as Associate Justice. Franklin Roosevelt died at Warm Springs, Georgia on April 12, 1945. He was succeeded by his Vice President, Harry S. Truman. The Allies in Europe were sweeping to victory. VE Day was less than a month away. In late April, Truman asked Justice Jackson to take on the job of Chief U.S. Prosecutor before an international tribunal to try high German officials accused of war crimes. Within days, Jackson wrote to the President accepting the position, and by an executive order dated May 2nd, Truman appointed Jackson as Chief Prosecutor. In accepting this job, Jackson took on an enormous responsibility, not just as an advocate for the tribunal, but also as a de facto ambassador and an administrator. He later said that it was the first case I've ever tried when I had to first persuade others that a court should be established, help negotiate its establishment, and when that was done, not only prepare my case, but find myself a courtroom in which to try it. There had never been such a tribunal before. The United States would prosecute and judge, along with its wartime allies, Great Britain, Russia, and France. Agreement as to which country would do what and when and had to be negotiated. A sizable and highly competent staff had to be assembled on short notice to depart for war-torn Europe for an indefinite period of time. Jackson made his first of several trips to Europe in late May 1945 to discuss preliminary matters. This was before the age of jet propulsion, and travel was by propeller plane. These planes could not cross the Atlantic without refueling. Thus, a flight from Washington or New York to Paris, like Jackson's, would stop first at Stephenville, Newfoundland, and then at Santa Maria in the Azores, before the final leg to its destination. When Jackson got there, agreements were duly negotiated among the Allies over the summer. Nuremberg, Germany, was designated as the place for the trials to be held. Not only was the job of chief prosecutor a once-in-a-lifetime opportunity, Jackson had very strong feelings about the importance of establishing a thorough record of the atrocities committed by the Nazis. In a June 1945 report to the President, he explained, The groundwork of our case must be factually authentic and constitute a well-documented history of what we are convinced was a grand, concerted pattern to incite and commit the aggressions and barbarities which have shocked the world. We must not forget that when the Nazi plans were boldly proclaimed, they were so extravagant that the world refused to take them seriously. Unless we write the record of this movement with clarity and precision, we cannot blame the future if in days of peace it finds incredible the accusatory generalities uttered during the war. We must establish incredible events by credible evidence. The trials began in late November 1945, and Jackson was the first to make an opening statement to the tribunal. In beautiful prose, Jackson spoke of the importance of making sure that each of the defendants, no matter how heinous the charges against them, received a fair trial. He said, "The former high station of these defendants, the notoriety of their acts, and the adaptability of their conduct to provoke retaliation make it hard to distinguish between the demand for a just and measured retribution and the unthinking cry for vengeance, which arises from the anguish of war. It is our task, so far as humanly possible, to draw the line between the two. We must never forget that the record on which we judge these defendants today is the record on which history will judge us tomorrow. To pass these defendants a poisoned chalice is to put it to our own lips as well. We must summon such detachment and intellectual integrity to our task that this trial will commend itself to posterity as fulfilling humanity's aspirations to do justice." He spoke for the entire day and won high praise from the American reporters covering the event. Several months later, he undertook the principal cross-examination of Hermann Goering, the highest-ranking German official on trial. Press reviews of this effort were mixed. Goering was a very shrewd fellow, and someone was telling me just the other day about one of the exchanges between Jackson and Goering during the trial. Jackson said to Goering, "Here you made these plans to exterminate the entire Jewish race." And Goering said, "Yes, just as the United States did with the Indians." After all the evidence was in late July, Jackson also made the first of the closing speeches for the prosecution. On August 31st, the tribunal recessed to consider the cases against the defendants. Its judgment was handed down a month later. Of the 22 defendants, 12 were sentenced to hang, 3 to life imprisonment, 4 to terms ranging from 10 to 20 years, and 3 were acquitted. Jackson understandably regarded his participation in the Nuremberg trials as the crowning achievement of his career. Telford Taylor, one of the other U.S. prosecutors at Nuremberg, believed that Jackson played what he called a unique and vital role in the Nuremberg trials. Taylor said that more than any other man of that period, Jackson worked and wrote with deep passion and spoke in winged words. There was no one else who could have done that half as well as he. But despite the praise for Jackson's contribution to the success of the Nuremberg trials, there was a great deal of criticism of the trials here in this country at the time. The criticism focused on 2 issues. The first was whether a justice of the Supreme Court should participate as a prosecutor in such a trial. The second issue was whether or not this sort of trial, not only the prosecutors but also the judges coming from the victors, would be in fact, if not in form, a kangaroo court. But this criticism softened as the court amassed evidence of evil intentions and deeds of many of the defendants, and also because 3 of the defendants were acquitted. Legal scholars also questioned whether the whole idea of such a trial, where there was no existing body of law, did not violate the principle embodied in the ex post facto provision in the United States Constitution. That provision requires that before criminal liability may attach to a person for a particular act, a law making the conduct criminal must have been on the books before he committed the act. Some of Jackson's own colleagues joined in this criticism. Justice William O. Douglas, between Jackson and whom no love was lost, opined in memoirs published many years later. He said, "Jackson was gone a whole year, and in his absence we sat as an 8-man court. I thought at the time he accepted the job that it was a gross violation of separation of powers to put a justice in charge of an executive function. I thought, and I think Stone and Black agreed, that if Bob did that, he should resign. Moreover, some of us, particularly Stone, Black, Murphy, and I, thought that the Nuremberg trials were unconstitutional by American standards." Whatever the merit of these objections, the Nuremberg trials were surely superior to the summary court-martial proceedings favored by some members of the administration and the summary executions initially favored by the British. Chief Justice Stone wrote privately in November 1945 that it would not disturb him greatly if the power of the Allied victors was, quote, "openly and frankly used to punish the German leaders for being a bad lot. But it disturbs me some to have it dressed up in the habiliments of a common law and the constitutional safeguards to those charged with crime." Justice Jackson's response to this criticism says a great deal about how he viewed the Nuremberg trials and also what a fine trial lawyer and an advocate he was. When, he said, did it become a crime to be one of a bad lot? What was the specific badness for which they should be openly and frankly punished? And how did he know what individuals were included in the bad lot? If it would have been right to punish the vanquished out of hand for being a bad lot, what made it wrong to have first a safeguarded hearing to make sure who was bad and how bad and what his badness consisted? Surely Jackson won this duel with Stone about the nature of the Nuremberg trials. Stone's biographer, Mason, sums up Stone's views of Jackson's service this way. He says, for Stone, Justice Jackson's participation in the Nuremberg trials combined 3 major sources of irritation: disapproval in principle of non-judicial work, strong objection to the trials on legal and political grounds, the inconvenience and increased burden of work entailed. Stone's concern for the effect of Jackson's absence had on the court is surely understandable, as I see from my point of view now, much more than I might have a long time ago. Jackson had been gone for 1 entire year of the court, and his colleagues had to take up the slack by dividing up what would have been his share of the opinions during the term. In any case in which the 8 justices were equally divided, the court had 2 alternatives, neither of which was attractive. They could simply hand down a 1-sentence order announcing that the decision of the lower court was affirmed by an equally divided court, an order which by custom says nothing about the governing law. The same issue which presumably the court thought important enough to review would have to await decision until another case in which all 9 members of the court were present. The other alternative was to simply set the case down for re-argument when the 9th justice returned. One of Stone's complaints was that he first learned of Jackson's acceptance of the role of prosecutor when it was announced by President Truman, and surely it would have been better had Jackson talked to Stone first. Stone didn't have any power to veto what he said, what Jackson did. I can testify to that fact. But it might have helped. It's difficult not to sympathize with either Jackson's or Stone's views. For Jackson, this was a once-in-a-lifetime opportunity, the high point of his professional life. His stature as a jurist undoubtedly contributed to the success of the Nuremberg trials, but over and above that, this was right up his alley. the use of the spoken and written word in a way that it would not have been for his colleagues or for most other judges. It was an advocate's dream. Speaking to the New York State Bar Association in 1947, Jackson said that his Nuremberg role, quote, was the supremely interesting and important work of my life, and an experience which would be unique in the life of any lawyer. When I served as Justice Jackson's law clerk, it was 6 or 7 years after the Nuremberg trials, and they had been controversial at the time. So I studiously refrained from asking him anything about them. But one day, a friend of mine who I'd known at graduate school was down visiting me. He was very interested in international relations. So he came into my little office adjacent to Justice Jackson's, and we were talking. I just wanted to show him the office. And Justice Jackson walked in, and I introduced him. And then he said to Justice Jackson, what I'd never dared say, how do you justify the Nuremberg trials? Here was this guy, 25 years old. Well, Justice Jackson, far from being offended, went into a 10 or 15 minute eloquent justification of the Nuremberg trials. He actually welcomed the question, and I was pleased there to be in the audience just to hear it. Jackson returned to the court for the term that began in October 1946 and served until his death in October 1954. He would have 8 more productive years on the court and would write more than his share of important opinions. But what strikes me most about his court work was his masterful use of the English language. What makes this mastery truly impressive is the fact that Jackson had no formal education beyond high school, except a year at the Albany Law School. And certainly law schools are not places known for their teachers of great English prose style. He wrote the opinion of the court in West Virginia State Board of Education versus Barnett in 1943, in which the court decided that even the need to stimulate wartime patriotism did not trump the First Amendment rights of school children to refuse to salute the American flag because of their religious beliefs. In his opinion for the court, he wrote, "If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. The very purpose of a Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities and officials, and to establish them as legal principles to be applied by the courts. One's right to life, liberty, and property, to free speech, free press, freedom of worship and assembly, and other fundamental rights may not be submitted to vote. They depend on the outcome of no elections." The Steele seizure case, which came in 1953 and ran its brief course from beginning to end during my first months as a law clerk, was one which was intensely covered by the media in the spring of 1952. It was during the Korean War, and President Truman had seized the steel mills to prevent a strike which would shut down the production needed for the military. All 9 justices who heard the case had been appointed by Democratic presidents, 5 by Roosevelt, 4 by Truman. And yet by a vote of 6-3, they ruled against Truman's authority to seize the mills. The court worked on a tightly compressed schedule late in its term. Review was granted early in May. The case was argued orally only a week later. Decision handed down in the middle of June. And of course, all the law clerks, as you can imagine, were just dying to find out how it came out. You know, the court held its conferences on Saturday in those days, and I remember George Niebank, who was from Buffalo, and I were the clerks at that time. We were anxiously waiting for Justice Jackson to come back, and so he said, "Come on in the office," and he turned and said, "Well, boys, the president got beat." Justice Black wrote the opinion for the court, but each of the other 5 who agreed with his result wrote a separate opinion. It is Jackson's, I believe, which has best stood the test of time. Presidential power, he said, is divided into 3 kinds. The first was where the president acted pursuant to congressional delegation of authority. Here, presidential power was at its apex. The president had not only the power of the executive, but the power of the legislature behind him. And only if the act was beyond the authority of the federal government itself would a presidential act be struck down. The second case was where the president acts in the absence of any congressional expression on the subject, one way or the other. There he has the power of the executive, but not that of Congress behind him. The third is presidential power at its nadir, when the president takes measures to deal with a situation in a particular way where Congress has said that it should be dealt with in a different way. This, in Jackson's view, was the situation in the Steele seizure case, and that was why he joined in ruling the seizure unconstitutional. Although no one else on the court joined Jackson's opinion at the time, the court has since cited it as governing law. In a poll of legal academics conducted some 30 years ago, Justice Jackson was rated as a near great among the 100 justices who had then served. It is worth noting that all but one of the 12 justices raised as great had either served considerably longer on the court than Jackson or had held the office of Chief Justice. Surely Jamestown and Chautauqua County can be proud of the career of their native son on both the national and the international scene. Thank you.
Now for part 2 with Eli Rosenbaum.
Actually, I'm introducing a speaker. I am not the speaker, but I do want to, as I look around the room and look at, gee whiz, all my friends and colleagues, and then you can look around the room and say, gee whiz, look at all my friends and colleagues, because again, these dialogues were originally meant and have become really just a collegial get-together of friends and colleagues who are devoting or have devoted their lives to justice. For that, you should all be justly proud. We have many, many people we need to thank, but I do want to single out the members of the Jackson Center who really, even though they're just, quote, a sponsor, and there are many wonderful sponsors for this event, the Jackson Center does the hard work of the administration and the logistics. So members of the Jackson Center team, why don't you just stand up? I just want to say thank you. And of course, we would really want to recognize Carol Drake, but Carol Drake is out doing what Carol Drake does well. She's making things happen. What a wonderful beginning of this wonderful 2 days, and what a wonderful beginning last night. Bill Kamen, we are still just in awe of your talk, and so honored to actually have seen and been there. And Bill, thank you very much for being here and gracing us and representing the Nuremberg prosecutors and all who have gone before you. So thank you, sir. We've asked a good friend, someone who I have known of for almost a quarter century, someone who I've known for over 15 years personally, and I've gotten to know him better and better as we move together through our particular professions of seeking justice or trying to seek justice for the oppressed. I've asked my good friend to address you because I think that it's very, very important to reflect on how the United States and the Office of Special Investigation has evolved and how it's moving in an appropriate and correct direction and expanding its mission. And I think Eli will be talking more about how that is also beginning to change. But I've asked Eli if he would be so willing to talk about his office, talk about the role of women in his office and the important place that they have in the important mission of the Office of Special Investigation of the Department of Justice. Eli has a tremendous resume. He is a Penn, he's a Wharton undergrad, MBA, Harvard Law School. But more importantly, I would frankly say, and I think you would agree with me, he is kind of Mr. OSI, Mr. Office of Special Investigation. I know he wouldn't want to have that imperator, but he started there as a summer intern in 1979, and now he heads it, and done everything in between. And he is the longest-serving investigator and prosecutor of Nazi criminals in post-war history. And so with that, I think, important distinction, I'll introduce Eli Rosenbaum, my friend and colleague, and our colleague, who will talk about his office. Thank you, Eli.
Thank you, David, for those very, very generous words. It's great to be here. I learned only a short while ago that I would be your lunchtime speaker, but it's a privilege for me. I am sorry that Gail Smith from the Office of the President couldn't be here due to a scheduling problem. I will also try to be brief because we are behind schedule, and I know everyone is eager to get back to the program in chief. Gail Smith brings to mind a related subject, as do the inspiring images that we've seen projected in the last 2 days of Justice Jackson, Bill Kaming, who we're very honored to have with us today, the much-missed Henry King, and heroes like Ben Ferencz and Whitney Harris. I'd like to read a letter that was written to Professor Harris last month and given to him earlier this month on the occasion of his 97th birthday. Dear Professor Harris, it is an honor to join your family and friends in wishing you the best as you celebrate your 97th birthday. Your life and career are rich with unique moments and experiences. In your time, you have seen true evil and known true progress. Along with your fellow prosecutors at Nuremberg, you made a significant impact on our nation's understanding of human rights and, more importantly, strengthened the world's collective faith in justice. This legacy is worthy of tremendous respect and admiration. Please accept my warmest wishes on this happy occasion. Sincerely, Barack Obama, President of the United States. Whitney Harris, of course, is a mentor to the Jackson Center and a great friend of this marvelous institution, and I know we all wish him well as he fights a medical battle. I've been asked to talk briefly about the work of our office and about the role of women in the work that we do. For most of OSI's life, since its creation in 1979, we were working on the World War II cases, Nazi crimes, Japanese crimes, perpetrated by individuals who were living in the United States, that is, who immigrated to the United States after the war, or who sought entry either for immigration purposes or even just to visit. In 2004, as a result of a provision in the Intelligence Reform and Terrorism Prevention Act, OSI's mission was expanded to include certain cases of perpetrators of post-World War II crimes. We share responsibility for what we in my office call the modern war crimes with the domestic security section in the criminal division, and an esteemed colleague of mine, Mike Segala, is here from that office. I think he's right here. Right? And of course, we work very closely with Immigration and Customs Enforcement, the FBI, and the State Department and other agencies. In our World War II work, of course, we encountered many cases in which women were victims, oftentimes victimized in a way that almost never happens to men. They were victims of sexual violence. I remember that most dramatically in our Japanese cases. About 13 years ago, having failed to obtain cooperation from the government of Japan in our investigative work, Japan to this day is the only country from which we have sought assistance that does not provide it. We were able, using our own resources, to identify people who were still alive in Japan who had participated either in the Unit 731 medical atrocities of the Japanese Imperial Army or in the so-called comfort women cases. These were women and girls, women and children, who, as you know, were abducted in China, in Indonesia, in Korea, and elsewhere that Japanese forces occupied, and they were put to work, so to speak, as sexual slaves, violated many times each day by officers and soldiers. Some of them were used as human shields near the end of the war. When babies were born, the babies were taken away. Many of the victims were killed by their Japanese captors. It was a total nightmare. The nightmare, of course, continued after the war because these women, I don't care, of course, for the expression comfort women, but it's actually the expression that the human rights NGOs that were formed specifically to fight for their rights used, so I hope I will be forgiven if I used it as well. They didn't even get a modicum of historical justice after the war. At least the Holocaust survivors have gotten that. But as you may know, there are many in Japan who deny that the crimes ever took place. There were, and perhaps still are, some Japanese officials who claim that these women, they don't like to talk about children, but that the women were volunteers and professional prostitutes, and that's an outrageous calumny. I think, I know that I will never forget meeting one of the victims, a woman who flew all the way in from Korea to meet with us. She was there with representatives of a Korean-American group, the Coalition for Comfort Women Issues, based in Washington. And a number of us who were prosecutors were in the meeting. And she told an absolutely horrific story of victimization that never really ended. She was unable to have children after the war because of what had been done to her, and that caused her marriage to fall apart. And of course, she was getting no compensatory justice nor really historical justice. And I would say the entire room was in tears by the time that meeting ended. A great, great and courageous lady who, by the way, though, said, you know, I could never speak in Korea and say the things there that I am saying here in this room. A short time later, in 1996, we decided we had enough evidence to bar these men whom I mentioned, perpetrators of medical atrocities and participants in the comfort women crimes, bar them from entering the United States. And we passed their names and identifying data on to the Departments of State, and at that time the Immigration and Naturalization Service, and the names were added to the watch list, the Border Control watch list, at which time we drafted a press release, as we had done in some of our Nazi cases, to announce that a category of offenders was now barred from entering the United States. Knowing that Japan had not been forced the way Germany had to confront its wartime past, we decided we'd better let the State Department see the text of our press release. No sooner had the text arrived than I was summoned to the Department of State to meet with some very senior people and to talk about our release, with which it was explained to us, a problem, a big problem. The problem being that we used the word rape, mass rapes, to categorize the crime. And I said, well, what's the problem with that? And they said, well, the Japanese don't use that word in connection with these events, and it will cause a great controversy in Japan. And the Japanese government will be discomfited by this. And I said, but you know, that's what the crime was. This was rape of women and children. They really weren't happy about it. And finally, after going back and forth for 25 minutes, I guess I was it's hard to believe I could have been more arrogant when I was younger than I am now, but I said, well, you know, why don't we send this issue of the R word up the flagpoles at our respective agencies and see how Secretary of State Madeleine Albright and Attorney General Janet Reno feel about it. And that actually worked instantaneously, and we compromised, I think, at one use of the R word up high in the press release. All of these cases, of course, are suffused with sadness, whoever the victim is or the victims are. But as I say, the cases involving women and girls as victims are of a special character. And one of the reasons we felt very strongly about issuing the press release, frankly, was, although it was not official government policy except for my office, was to give a boost to the human rights groups that were fighting for the rights of the survivors of those crimes. And we were very gratified at the reception that we got in the human rights community, a community that, although we are government employees and federal prosecutors, we like to feel we are part of. We also have, I'm sorry, I should tell you the denouement of that story. After the press release came out, I got a call from the Japanese embassy. It appears that the government in Tokyo, which was notified by the State Department, had neglected to alert their embassy in Washington. And a senior diplomat asked if he could meet with me, and I said, well, of course, when would you like to meet? This was about 5 o'clock. He said, tonight. No one had ever asked to meet at night. Sure, 7 o'clock, okay. And he came over with a lawyer from the embassy carrying a big book of treaties, and he was very upset about our announcement. And he said, you know, your press release says that these women were, some of them were that they were tortured, they were raped, they were even killed. He said, what's the proof of that? I said, well, with all due respect, sir, this is really not open to historical debate. There are scholarly works written on this subject. Some of the men who were involved in this have spoken of it in Japan rather courageously. And beyond that, I said, we had the privilege of meeting here in this very room with one of the surviving victims. And he looked at me and sort of rolled his eyes, and he said, this woman, she was Korean? And I said, yes, as a matter of fact, she's from Korea. And he said, oh, I see. And then he said, you know, your law covers, makes excludable people who took part in persecution. He said, and it's not, how could it be that persecution was committed in this case because under some concept of international law that I'll turn to the international law practitioners here to explain to me. He said that when Japan occupied Korea, for example, that people who lived there became, by force of international law, Japanese nationals. So the victims could not have been persecuted on the basis of national origin because they were now of the same nationality as their tormentors. And I said, well, you know, our statute also speaks of persecution on racial grounds. Would you say, for instance, that these Korean women, say, were racially Japanese? And the two diplomats in unison went, racially? Oh, no, not racially. And then they had one other argument, which was that there was a treaty signed by the United States and Japan in the early part of the last century, 19-something, in which he said the two countries guaranteed that the other's nationals could enter one another's territory. And I apologized and said I wasn't familiar with that treaty. I was a young boy at the time. But that I was sure that the treaty did not guarantee that all of the two countries' nationals could enter the other's territories. And I said, in fact, I remember when I was a youngster that there was an incident that showed that the Japanese government accepts the concept that a sovereign nation has a right to determine which non-citizens may enter the country. I said, I recall that John Lennon of the Beatles was barred from entering Japan because he had a marijuana conviction. marijuana possession conviction, I believe, in the United States. And being a federal prosecutor, I was, of course, duty-bound to say, you know, while that's a very serious offense, it certainly pales by comparison with the crimes committed, you know, by Unit 731 and in the Comfort Women cases. And he was very embarrassed, and he looked down and he said, actually, it was Paul McCartney. So, with all due respect to Sir Paul, sorry about that. As David mentioned, and I speak for both of our offices, the Domestic Security Section and OSI, have from the start had women prosecutors and women leaders. The chief of the Domestic Security Section, Teresa McHenry, formerly a prosecutor at the ICTY in The Hague. I've had both of my principal deputies have been women, Ronnie Edelman and more recently Susan Siegel. And there have been times when I would say half or even slightly more than half of our prosecutors have been women. And we, of course, encourage women to apply for positions in our office. And one of the great privileges I had in my career was in 1996, the final reunion of Nuremberg staff, and it was held in Washington. At that time, you could actually assemble over 100 people, among them the great Telford Taylor. And one of the prosecutors I met at that conference was Belle Mayerzek. And really an extraordinarily accomplished person before Nuremberg, at Nuremberg, after Nuremberg, and also a wonderful, engaging person. And I asked her if there was any possibility that we could entice her to come down from Westchester and give a talk to our staff. I thought it would be not only fascinating, but a great morale booster for our staff to meet someone who had accomplished what she had. And I thought it would be a particular encouragement to our women's staff at all levels and our interns as well. And we were so lucky. She came down and did that, and she was hugely inspiring. And it's just something that none of us will ever forget. Greg Peterson recently asked me about that, and I told him, and he said, "Gee, did you tape it?" And I said, "No, I don't think so." And then I thought, wait a minute, we must have taped that. I wouldn't have let that go on without taping it. And so I checked, and we did, and the Jackson Center is now the home of the DVD of Belle Mayerzek speaking at the Department of Justice, and I hope that'll be more widely available soon, because it was just an absolutely extraordinary day for us at the Department of Justice. I think it's an extraordinary day for efforts to preserve, protect human rights, and to vindicate the rights of the victims of those crimes. We have a new administration. We have a new ambassador for war crimes issues coming in, following in very distinguished footsteps of his predecessor, Stephen Rapp, also a great friend of the Jackson Center, someone who has spoken here before and was a panelist last year. The head of the criminal division, Lanny Brewer, for whom Michael and I both work, has announced that our sections may be unified shortly. There'll be sort of a rationalization of the human rights law enforcement function within the Department of Justice. We have a president who has been quick to address human rights issues, both domestically and internationally, and has spoken so eloquently about the imperative of using the law and other tools at a great nation's disposal to protect human rights. It is an honor to serve under his leadership, an honor to serve in the Department of Justice with great colleagues like Michael and Teresa and the women and men of my office. And I thank you so much for putting up with me today.
The Jackson Center is a historical and educational facility dedicated to preserving the legacy of this country lawyer who became Solicitor General, Attorney General, a Justice of the Supreme Court, and served as chief prosecutor at the Nuremberg trials of Nazi war criminals following World War II. To learn more about this program, Robert Jackson, the Jackson Center, and upcoming events, the Jackson Center is located at 305 East 4th Street, Jamestown, New York, and found on the web at www.roberthjackson.org or contacted by telephoning 716-483-6646.